Is it worth it? Is it worth the broken relationships? Is it worth the sleepless nights? Is it worth the debilitating anxiety? Is it worth the stress? Is it worth the panic attacks? Is it worth the arguments? Is it worth the resentment of others? If you are disputing with other family members regarding an estate of a loved one, you need to ask yourself, is it worth it? Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. The probate process is already costly and complicated. When family disputes turns into probate litigation, it is very difficult to predict what the cost will be and who will be on the hook for the cost. You don't want to have to spend $20,000 to recover $10,000, do you? Parties in an estate administration need to understand that fees and cost are completely different. An attorney will charge a fee to represent you in a lawsuit, and as a result, you'll incur costs related to vendors, court fees, court reporting fees, process server fees. Again, the question you need to ask yourself is it worth it? For example, administrators and executors have a fiduciary duty to defend a will contest. Beneficiaries and heirs have the right to challenge how administrators and executors execute their duties and responsibilities as the personal representative of the estate. The question is it worth it? Let's say a family member files a will contest alleging incapacity, undue influence, fraud, a mistake. The filing of that lawsuit will bring that probate process to a grinding crawl until that lawsuit has been resolved. Remember, both sides will likely hire an attorney, and the attorneys will argue that both sides are correct. And the process of proving either side wrong or right will be timely and costly. Even if you are entitled to attorney's fees, recovering those fees may be next to impossible. If a probate judge determines that the heir or beneficiary contested something in the probate administration without reasonable cause or in bad faith, that heir or beneficiary could be held liable for that cost, and the cost can be taken from that heir's or beneficiary's inheritance. And if that inheritance amount is insufficient to cover that cost, that heir or beneficiary can be held personally liable for that money. The same rule applies to an administrator or an executor if a probate judge finds that they brought a case in bad faith or without reasonable cause. Again, the question to ask yourself, is it worth it? Question of the day. Have you ever filed a lawsuit during a probate administration? If so, how long did it take to resolve that challenge? How much time did it add to the administration process? Let us know in the comments below. How costly are challenges to a probate administration? that is very hard to predict. However, you need to ask yourself, is the challenge worth it? You may want to consider other options, such as really making a big effort to talk it out, or mediate the problem, or possibly go through some means of arbitration. If you walk down the road of probate administration, it literally can cost the estate and or yourself tens of thousands of dollars, not to mention all the emotional stress and baggage that will come along with it. I'm Darrell Williams. This is Win-Win Realtors TV. If you've gotten value from this video, be sure to like, share, and subscribe. If you have any questions for me, my contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need legal advice, please consult an attorney. If you need an estate planning or probate attorney here in the Southern California area, feel free to contact me for a referral.